Should be working.
All right, meeting is now
started.
streaming live on YouTube.
Yep, hang on, not yet.
Sure. This is a new era that we're all living in here, but so far this has proved to be a very effective tool for us to have local committee meetings and to have obviously the big forum we had on April 14th. And
It's going.
okay. So is everybody in the room more or less, Ted?
43 so far.
Okay.
Yeah.
Well,
44.
I'm going to start, and so we can get going and people can keep entering the room. So welcome everybody who's to the TCDC, Tompkins County Democratic Committee District Attorney Candidates Forum. We're happy that you're here in the comfort and safety of your homes, whether you're watching us, whether you're in the Zoom meeting live or whether you're watching live streaming on YouTube, or for all those who join us later to see this important discussion between Matt Van Houten, the incumbent district attorney, and Ed Kopko, his challenger. We thank them both for participating and being here to share their views with us. And tonight the discussion is going to be moderated by Liz Hartman, and very much appreciate her doing that. And Renee Farrow has agreed to the very trying task of being the timer. It looks simple, but it's not. So thank you, Renee. And you've been listening to me talk to Ted Crane, our Director of Technology for the TCDC, who's done a great job of making Zoom work for us and is doing that very job tonight, along with a lot of other things he does behind all those magic buttons and screens. And Jennifer Lyons, who's helping him with that, and who is the director. Oh, by the way, Renee Farrow is also a director of communications for all traditional media. And Jennifer Lyons is helping out with this, and she's our director of social media. And Katie Nicholson has been helping with compiling the questions. So with all that said, let me just say a couple things quickly. One is that we will be having 2 more assembly candidate forums, one on May 27th at 7 o'clock, same virtual format, if you will. And then we'll have another assembly candidate forum on June 9th. And so you can look forward to both of those. And we hope that you will go to our website at the Tompkins County Democratic Committee websites and to our social media sites. And there's always new information there about the various campaigns. Leslie Danks Burke and Jim Barber for the state Senate, and Tracy Matrano for Congress. And there'll be more and more information about ways in which you can participate in those campaigns and help. And of course, there's information about the district attorney's race and the assembly races as they unfold for the up to the June 23rd primary. And while you're there, if you want to stop and click on our donate button and help contribute to the cause, we certainly appreciate that, to help us continue with our work in this very, very, very important election year. So with all that said, oh yes, so technical housekeeping information. So you would want to watch this in gallery view. If you look at the top of your screen, you'll see speaker view and gallery view. You can experiment with either, but in gallery view, you'll see both candidates, Liz and Renee. If you go to speaker view, you only see the one that's actually talking. Also, if you're seeing a lot of empty black boxes on your screen, when you put your cursor over the top right corner, at least on the way on my computer, top right corner of that person's box, and click and the little dots, you'll see the option to hide the non-video participants. And if you click on that on any one of those boxes, they should all disappear. So you'll just be seeing, when I stop talking and get out of here in about 30 seconds, you'll just be seeing Renee, Liz, and Matt and Ed. So was there anything else I forgot in that, Liz?
No, I think you covered it all.
All right, very good. Well, with that, thank you again so much, and enjoy the discussion.
Thank you so much, Jim. I want to go over the timing a little bit so our audience knows how this is going to work. We're going to start off with introductory statements. Each candidate will have 3 minutes for introductory statements. And we'll be starting with Ed and then Matt. Then we'll move into the question and answer phase. And every time I ask a question, I will rotate who gets to answer first. Candidates will have 1 minute to answer. And when there's 15 seconds left, they will see a little warning that they've got 15 seconds left, and then a little stop sign when they've reached 1 minute. We will plan to take a short 3-minute break in the middle. And then when it's time for closing statements, we will allow 1 minute again for closing statements. And in that case, Matt will go first and Ed will go second. So that's how we're going to be doing this. So thank you so much, Ed. Thank you, Matt. And without further ado, we're going to go ahead and get started with the introductory statements. So Ed, the floor is yours.
Thank you so much. And Jim, thank you. And thank you to your team for putting this together. I'm Ed Kopko, and never did I imagine as a candidate for district attorney that I'd be walking up to a bank teller with a mask on asking for money. But those are the circumstances that we find ourselves in here. Now, I can look out my office window right next to the courthouse, and I see hundreds of people protesting the policies of the district attorney. These are our neighbors. These are people that live in our community. There is a deep divide between these members of our community, LGBTQIA, people of color, that feel an injustice. And we have the opportunity to right this injustice. We have an opportunity to come together to adjust this and to make certain that everyone recognizes and feels that we have a fair criminal justice system. I've been thinking a lot about the criminal justice system, and I encourage you to do so as well. Think of it as 3 parts. Think about the first part as being society at large, where there's poverty, there's lack of education, there's drug abuse, there is health problems, there's violent criminals. All of these problems get funneled into the court system, and that's the second segment of this. Now, while we have a very good court system here locally, and there's a lot of specialized courts and people are trying to do the right things, the courts are ill-equipped and they're not intended to handle all of society's problems. The third aspect of this is the incarceration system, whether it be jail or prison. And the first aspect that we have to ask ourselves is, what do we intend to get out of the prison system? We're just going to ship people off and warehouse them? What is the end result that we intend? It is commonly thought that the first day of reentry begins on the first day of the sentence. And we have to be prepared when people have fulfilled their debt to society and they come back. And there has to be appropriate programs for these people to be contributing members of society, to play their appropriate role so that we're all safe. And we can do this together. This is a task that is beyond simply the court system. And as the district attorney, I will be looking to formulate new programs to institute changes both in society, our local community, and in the court systems. Thank you.
Thank you, Ed. Matt?
All right, thanks, Liz. First, I would like to thank the Democratic Committee, local Democratic Committee, for this opportunity, for putting on this forum. I think it's a really important opportunity to discuss the issues that are important in this community. So I'm grateful and looking forward to the questions later on this evening. Public safety and justice are my priorities as district attorney. That we can absolutely achieve public safety by using our alternatives to incarceration to help people address the issues that cause them to commit crimes and to help them become productive and healthy people. And we only use incarceration as a last result when there are no other options. The criminal justice system is full of tragedy, pain, poor decisions. We have to remember the victims in the cases, as well as the defendant and their families. These are all human beings. Often people break the law because of the personal struggles, whether it's substance abuse, whether it's homelessness, mental health. And we have to recognize what's causing them to come into the criminal justice system. Being a prosecutor requires an open mind and a genuine interest in what makes people do what they do. Doing the right thing takes time. It takes time to learn about the human beings involved. It also means playing by the rules, being ethical, and respecting the rights of the people in the criminal justice system. In my office, we spend a lot of time focusing on decriminalizing people. What I mean by that is that success often is when a case is dismissed. It doesn't mean we dismiss it outright in the beginning. It means that the person may have to get a substance abuse evaluation, or they may have to participate in treatment court, or they may have to do community service, or they may have to pay restitution and prove to the court that what they did was an aberration, and with a period of supervision, we don't have to worry about them. When those things happen, we're happy to dismiss those charges, and we don't need to have someone end up with a criminal record in order to achieve success in our system. And we have a lot of tools in our local criminal justice system that enable us to use those alternatives. Other times we do need to seek convictions and to seek incarceration. And in those cases, it's especially important that the prosecutor act ethically and fairly. So I have 7 other attorneys in my office. 4 of them are women. They share my philosophy that doing the right thing is not about wins and losses. It's about doing the right thing, finding a solution, and helping people. So thank you.
Thank you, Matt. So we're going to move into the question phase now. And now I'm going to ask Matt to answer first. And our first question is, how would you characterize your leadership style? And how do you apply that style to the district attorney's office?
Great. Well, I would say that I lead by example, which I believe is extremely important as the top prosecutor in our county. Leading by example means that I handle a full caseload. I go to the town courts. I prosecute cases. I try cases. I present cases to the grand jury. And by doing that, I know what's happening at every level of our criminal justice system. And it enables me to supervise the 7 attorneys who work for me in the best way possible, because I know what they're experiencing. I know what courts are doing. And so leading by example, in my experience, is the way that I would always choose to be a leader.
Great, thank you very much. Ed?
Yeah, my leadership style differs substantially. I prefer to lead by creativity, innovation, open to the opinions of other people, open to the opinions of the community, searching out what is the best way to make our community as safe as possible, while looking to see what we can do for individuals who have run afoul of the law. I rely upon research and studies to understand why people are behaving in the ways that they are behaving. I use that information to make very informed decisions about, say, for example, the prosecution of youth, or the prosecution of people with substance abuse problems. Those people are not criminals, they're patients. I very much try to be smart on crime, not tough on crime.
Thank you very much, Ed. And Ed, now you'll go first for our second question, which is, how would you balance supervising the assistant district attorneys with managing your own caseload, if any, and other responsibilities?
Well, as I just said, I see myself as being an innovative leader, and I would have a staff that would be highly trained to be sensitive to racial issues. My staff would be highly trained in dealing with Lgbtqia. They would be highly trained in dealing with people of color. And there would be very clearly delineated roles for these people. They would know exactly what type of discretion that they had. And I would be consulting with members of the community so that my office and my staff is always reflecting the values of the community. And I would do this with the sense that we first have to keep everyone safe, and then we have to keep as many people as we possibly can out of the criminal justice system.
Thank you. Matt?
So balancing my responsibilities as a prosecutor and a supervisor, that starts with collaboration and communication. And we have regular meetings. We talk about cases and common issues. And frankly, it also involves, in terms of balancing, spending more time in the office. I work 7 days a week in order to maintain a full caseload and to try cases and to go to town courts, and also to balance the budget and to supervise. That requires more time, and I'm happy to put that time in. I have been putting that time in. My car is at the office on the weekend, both days. And because I'm committed to this job, I'm committed to this community. That's my way of balancing is by putting in the time.
Thank you. So now we're going to move to the third question, and Matt, I'd like you to answer first. How do you anticipate the county's budget shortfall impacting the DA's office?
Well, that's an unfortunate question, but a realistic question. I mentioned that I have 7 assistant DAs right now. I did have 8. There's been an opening for one assistant DA since the beginning of the year when we lost someone to a different job. And I don't anticipate that job will be filled. There is a hiring freeze in the county. So I have not tried to fill that position, although we did advertise it for a while. I think the reality is that we may not get that position back, and we will have to figure out a way to spread out the workload among the 8 attorneys instead of the 9 that we had. But I think it goes back to communication, communicating with the legislature, being pragmatic and being realistic about what we need, the resources that we need to be able to succeed. And I think I have that relationship with the legislature, so that when I do ask for something, my point of view is taken seriously.
Thank you. Ed?
Yes, thank you. I have a firmly held belief that we don't need all of these prosecutions, and we probably don't need all of the assistant district attorneys that we have. Under the system that I have in mind, there would be a lot fewer prosecutions. We would concentrate on the major crimes, the felonies, the people that hurt us, the people that there is no other hope but for them to be separated from us. All the other people that are involved in the criminal justice system, people that have, for example, mental health issues, people that have drug issues, these people, instead of seeing a prosecutor, they could go see a local pastor for some help. They could get some guidance from the community. I would work with the community to set up programs short of a prosecution. And I think that I could streamline the office and save money in that fashion, only prosecuting the people that need to be put away.
Thank you. So our next question, Ed, will start first. In the recent rollback of New York's bail reform, additional offenses were made eligible for bail. What is your opinion on this change?
Well, I was enthusiastically in favor of the original bill, but the legislature has decided that they're going to add a number of offenses to the ones that existed where bail can be required. I personally believe that bail is a way of keeping poor people in jail awaiting trial. So what I would do is start from the very beginning, and I would make smart prosecutorial decisions about the crimes that are going to be laid against these people so that they fit into the categories that they can obtain bail. And that is the simplest way of handling this, because then those people get out and they're not jailed because they're poor. Other people who have serious crimes will deal with that. And some of those people may have to be put away pending trial so that all of us are safe. And I'm perfectly willing to do that.
Thank you. Matt?
Well, bail is something that we've taken very seriously my entire term. And I instituted a policy of presumptive release for nonviolent offenses from the beginning of my term. I do think that the additional offenses that were added in the rollback, partial rollback of the bail reform were appropriate. For example, there's an offense where you cause the death of someone in a motor vehicle accident or incident prior to the law being changed, that was not eligible for bail. And we have to remember that bail is not a punitive measure. It is to ensure someone's return to court. And naturally, when someone is facing 5 to 15 years in prison for killing someone while they're drunk driving, that's a factor in whether they may return to court or not. But absolutely, no one should be in jail because they don't have the ability to pay bail, and for that reason only.
Thank you. Matt, I'd like you to answer the next question first. Should the DA's office use special prosecutors for crimes committed by police officers? Why or why not?
I make that decision on a case-by-case basis. There have been cases during the last 3.5 years that I have asked for a special prosecutor. And I believe that that is something that is really important to use in order to ensure the community has confidence in a prosecution. When you're prosecuting a police officer, which I have done, you face the presumption that either you're going to treat them preferentially or you're going to treat them harshly, more harshly, because they're a police officer, neither of which is fair to the community or to the individuals involved. So when there is that presumption that can't be overcome, then I think it's appropriate to have a special prosecutor, and that promotes confidence in the community that this matter will be treated completely impartially. So it's really an individual basis, individual decision.
Thank you. Ed?
There are no circumstances where the district attorney should disqualify himself from the prosecution of a police officer. No one is above the law and no one is below the law. In the past, Mr. Van Outen has disqualified himself from the prosecution of a deputy sheriff because he claimed he had a working relationship. There is no reason to disqualify, because what it does is create in the mind of the public that the district attorney is giving preferential treatment to the police. That further undermines the entire integrity of the judicial system. It undermines and erodes the trust that people have in the criminal justice system. Police officers are noble, brave, and come to our aid unhesitatingly. There are a few rogue police officers, just like there's rogue attorneys or rogue judges, that need to be prosecuted, and it's the job of the district attorney to do that.
Thank you.
Can I have a minute to respond to that, please?
You may each have 1 additional minute on this topic.
Great. Thank you. The particular case that my opponent is referencing is a case where a young woman accused a sheriff's deputy and another individual of raping her. And you have to remember, our sheriff's department has a few dozen road officers. In addition, that particular deputy who was accused of this crime, his girlfriend was a New York State trooper who was also in our office frequently handling arrests and prosecutions. Imagine being that young woman who has made these serious allegations of rape and coming into my office to prepare to testify at grand jury and having to walk the gauntlet of other sheriff's deputies, friends of this person that she has accused, or maybe the girlfriend herself of this deputy. How does that person, how do we protect her rights? That's another huge factor that I incorporated into my decision.
Thank you. Ed, you have another minute on this topic.
None of that response addresses the responsibility of the district attorney to fairly and impartially enforce the law, whether it's a police officer or some other person. All victims of crime are entitled to dignity and respect and sensitivity and compassion. This particular young lady was no different, and she deserved all of those things. But we're not talking about that. We're talking about the responsibility of the district attorney to create not only the impression, but also the reality that the district attorney is fair and impartial. And when the district attorney recuses himself for the stated reasons, that is not a proper justification in the eyes of the public, because it's the duty and the responsibility of the district attorney to prosecute rogue police officers.
Thank you. On a related question, Ed, you will go first. What standards would your office use to determine when to prosecute a police officer who engages in official misconduct?
Well, the first thing that you have to remember is that the police serve us nobly and honorably, and I'm entirely in favor of the police. In the instances of a rogue police officer who has committed a crime, those circumstances would be thoroughly investigated. I personally do not believe that the police can police the police. I think that's the job of the district attorney to do that. I am adamantly opposed to internal affair investigations. If I'm the district attorney, there are not going to be internal affairs investigations. If an officer is accused of criminal conduct or wrongdoing, my office is going to investigate that with complete transparency. And the community in Tompkins County will know exactly what is happening there, because these people are our servants and they're entitled to know that.
Thank you. Matt?
Well, prosecuting a police officer is the same as prosecuting a civilian in many respects, in that you have to evaluate the evidence and fully investigate the case. I don't think that it reflects an understanding of the system to say that there will be no internal affairs bureaus, because those are parts of the state police, parts of the local police. We don't have the ability as district attorneys to ban a part of another agency. We have in the past conducted investigations of police officers who violated the law, and during so became firsthand witnesses of evidence that ultimately resulted in the individual being convicted of a crime. So there are similarities to prosecuting a civilian, but there are differences, and we have to be aware of all of those as we try to be as fair as possible.
Thank you.
May I add to that? May I have a moment there?
Let's save it if you have something later to when there's another follow-up. I'd like to keep moving because we're spending a lot of time on this topic and still have 2 more questions.
Sure.
But you can probably fit that in, what you'd like to say in one of the next 2 questions. Matt, I'd like you to answer this question first. What will or are you doing to ensure that there is a clear degree of separation between law enforcement and the prosecutor's office?
We do that. I do that on a regular basis. Going back to my time in the military, I was asked by a general once whether it's important to be respected or be liked by your troops. And absolutely, it's much more important to be respected than liked. And I can say that my relationship with the police is very similar to that. I very often tell them things that they don't want to hear, that they've done a poor job of investigating, or they need to finish up or follow up on an investigation, or that the case is the evidence is inadequate. They don't like that, but they respect my point of view, and that's more important. So our relationship is healthy because we communicate. I explain to them why a case may be deficient or the evidence may be lacking, and we build on that. And I think that's a positive, strong relationship, but it's a respectful one, and the authority is delineated.
Thank you. Ed?
You know, the current relationship between Mr. Van Alden and the police is an improper relationship. The clearest example of that happened in the Commons case with this young woman, Rose DeGroat. The police overreacted and charged her with a felony. Mr. Van Alden came out with a very public statement saying that he had reviewed all the videotape evidence and that he was reducing the charges. To his credit, he actually reduced the charges. Then he met with the Ithaca police. And then, quite inexplicably and improperly, presented the same case to the grand jury and indicted this one young woman on the same felony charges that he had dismissed 3 weeks earlier. That was an improper influence by the Ithaca police, and that would not happen under my administration.
Thank you. And I'll note that we do have a specific question coming up later on this case, so you'll both have an opportunity to speak a little bit more about that. The next question, which Ed will answer first, is, in general, how would you handle a fatal use of force incident involving local police?
Well, there is an executive order in New York that gives the Attorney General in New York the authority to supplant the jurisdiction of the local district attorney in cases of a police shooting. If that was not triggered, if those special circumstances allowing the Attorney General to come in was not triggered, I would conduct a very thorough investigation using all of the resources of the district attorney's office, including the grand jury, to try to determine all of the circumstances that happened in fairness to the police, in fairness to the victim, and in fairness to our community. Only that type of transparency will suffice to satisfy for justice.
Thank you. Matt?
All right, thank you. There is an executive order that requires that the Attorney General investigate any cases involving deadly force used by a police officer of an unarmed civilian. So the first level of analysis is to determine the circumstances of the incident and to determine whether the civilian was armed or unarmed. And that requires communication with the Attorney General's office and an investigation that is to be conducted by another police agency. Recently, that happened where something happened at the Ithaca Police Department, and the New York State Police came in and conducted the investigation. I was there personally overseeing that investigation from probably 25 minutes after the incident. And it does require careful supervision in order to make sure that the process is followed thoroughly and completely.
Great, thank you. So the next question is actually just directed at you, Matt, and then there's one that's just directed at Ed. So Matt, you have had 4 years as district attorney. What do you believe is the greatest strength and greatest weakness as the office is currently constituted?
I think the greatest strength is our engagement in the alternatives to incarceration that we have in our community. I was on the task force that started the Wellness and Recovery Court, which is essentially a mental health court. We're going to push to expand that court to handle felony cases and to handle cases throughout the county as opposed to just in the city. We're also fully engaged in felony treatment court, misdemeanor treatment court, integrated domestic violence court. So I think that all of those things are really powerful alternatives to incarceration that our office is completely engaged with. If I had to say a negative, it would be balancing communication with the public. Ethically, we're not allowed as attorneys, not just prosecutors, but attorneys, to communicate with the public about evidence relating to a case. That's often frustrating because I would like to talk to the community and tell them what's going on in a case, but ethically, it's more important to protect the rights of the accused.
Thank you. And Ed, just to you, you have represented individuals in civil rights and police misconduct cases locally. How do you believe that will affect your relationship with police agencies should you be elected?
I think that would strengthen my relationship with the police because the honorable, noble police officers actually don't want to have anything to do with the rogue officers. The local civil rights cases that I've had for excessive force, for example, making an illegal arrest, and indeed, I have had many of those types of cases because I'm a champion of the constitutional rights of people. And in those instances, I have the understanding and the cooperation of other police officers who don't want to be tainted by the improper conduct of their colleagues. So that would only enhance my relationship with the police because they understand that justice is the goal here.
Thank you. Ed, I'd like you to answer first the next question. What is the role of the DA's office in ensuring that people are not treated unfairly because of their race or sexual orientation?
This is absolute paramount because people have to have respect and trust in the integrity of the system. Vast amounts of research support the fact that if people believe and trust in the system, they are more likely to comply with court orders. They're more likely to comply with probationary terms. They're more likely to cooperate with people if they believe that they're being treated fairly. On the other hand, if the people have no trust in the system, if they have no trust in the district attorney's office, if they don't believe that they're being treated fairly, we have hundreds of people from our community standing out in front of the courthouse protesting those policies because they lack faith in the system. And that is the worst possible thing that you can have in the criminal justice system, is a lack of faith by the community.
Great, thank you. Matt?
Thank you. I want to start out because this has been referenced twice now. I pay attention to protests, and I think that it's probably more accurate and less disingenuous to say that there were protests about decisions in a case and not protests about policies. And in every criminal case, there are people who are upset about the decisions that are made and the consequences that are imposed. And if that's a measure of success, then we're in trouble. In terms of how we as an office interact and try to do the best job that we can in the community, I have conducted trainings on implicit bias in my office for the attorneys, bringing in experts, and I have gone to as many opportunities for training and conversations as I possibly can to talk about implicit bias. And I'm always willing to engage in those uncomfortable conversations.
Great, thank you. We will do one more question before we have a short 3-minute break. And Matt, I'd like you to answer this one first. What will you do, or what are you doing to build cultural competency around LGBTQIA issues in the DA's office?
cultural competency. That's a question that is an interesting question. We look at every case and evaluate whether there was a factor of bias or hate, or whether that was involved in a particular case. We prosecuted the case of the terrible homicide of Josiah Barrios in 2017. That's something that we talk about a lot in our office and collaborate about is, are we being fair? Are we incorporating everything that we need to incorporate? And we have not had specific trainings about LGBTQIA matters, but this is something that I'm very open to and absolutely committed to protecting the rights of everyone in Tompkins County from discrimination.
Thank you. Ed?
The district attorney has had 3 years to do this type of training, and absolutely nothing has happened. Now, everyone is entitled to respect. Everyone is entitled to dignity, whether you're a member of the LGBTQIA community, whether you're a person of color. All of these policies need to be in place because this sort of training, this sort of sensitivity, this sort of understanding forms the predicate for making prosecutorial decisions. These people are entitled to be protected. Sometimes it's the police that are actually abusing these people. Now, I will set a policy that everyone's rights are going to be recognized. Everyone's rights are going to be protected. And my entire staff will be trained and sensitive from the very beginning, and we won't wait 4 years to do it.
Thank you, Ed. We will now take a 3-minute break, and then we will come back with another question, and Ed will be the first to respond to that question. And we'll be starting again in about 1 minute. Thank you so much to everyone who has joined us. We're about halfway through right now, our forum with the 2 Democratic candidates for District Attorney, Ed Kopko and Matt Van Houten. We will be starting again in just a few moments. Welcome back, Matt and Ed. We're going to go ahead and make sure that we have you unmuted before we get started with our next question. Great, it looks like Ed is unmuted and Matt is unmuted as well. Great, so this next question I would like Ed to answer first. What special considerations should the DA's office take in the sentencing of people who are charged with sex offenses?
There's a vast body of science that indicates that people that commit sex offenses cannot be rehabilitated. There is a very high recidivism rate for sex offenders. They create a great deal of danger for the community. They create a peril for their victims who can be traumatized for their entire life. Sex offenders are people, in my view, in a special category that need to be separated from the rest of us because they cannot be rehabilitated effectively. And I would look most particularly at the victims in this case to make certain that the victims are going to be totally protected and never harmed again.
Thank you. Matt?
Sex offenses are one of the most disturbing crimes that can be committed, and we take those cases very seriously. We have had multiple cases in recent history where we have advocated for long prison sentences for people who have either been found guilty or been convicted at trial or have pled guilty of the top charge of sex offenses. It involves advocacy. If the victim is willing to testify at the sentencing, that's a very powerful tool. It's our goal to protect that victim from being re-traumatized, which is often something that we have to be very sensitive about, but protecting them in the form of an order of protection, as well as the longest level of supervision, including registry and the sex offender registry, is what we advocate for in sentencing for sex offenses.
Thank you. Matt, I'd like you to answer this question first. How does the DA's office ensure transparency in the way it prosecutes defendants?
I talked about this a little bit earlier. That's a matter of frustration because you can look at a case at the end of the case, but while a case is being prosecuted, it is absolutely improper to talk about the evidence in the case. And every case is different. So we cannot just start talking to the media about the defendant or what they did or what the proof is going to be. That deprives the defendant of a fair trial. It's not fair. And neither the prosecutor nor the defense attorney should be doing that. In terms of looking at cases after the fact, we are members of the CJATI board that looks at alternatives to incarceration, looks at cases and statistics, and comparing one case to another is really difficult because every case is fact specific, but we're very open to comparing cases after the fact.
Great, thank you. And a follow-up question for you. Could you please explain what the CJATI board is?
Sure. That stands for Criminal Justice Alternatives to Incarceration. And it's a board that is made up of people from many agencies, including the substance abuse treatment agencies, probation, DSS, sheriff's office, the jail, the DA's office, county administration, the legislators, all of whom have one goal, which is to maximize our community's use of ATIs, alternatives to incarceration. There are peers who are formerly incarcerated individuals who also participate in that group and provide really valuable input. So that's something that I go to every month. It's a monthly meeting, and it's really a valuable tool for us as a DA's office.
Great, thank you. So Now back to you, Ed, and we will be giving you 2 minutes to respond to keep the time equal.
New York Rule of Professional Responsibility 3 specifically allows a prosecutor to make public comments about criminal prosecutions. It also gives to defense counsel the same opportunity to make public comments to refute the statements made by the prosecutor or statements made by the police in matters of fairness. So that's the first point that you have to keep in mind. You are not totally silenced about these things. Many of these cases hold vast public interest. The public is entitled to know about the basic facts of the case. And in fact, you are permitted as a prosecutor and as defense counsel to make some public comments. I would be very judicious in that because I'm an advocate for the constitutional rights of people. I believe that everybody should have a fair trial. I believe that people should have adequate and experienced defense counsel for their benefit. And I believe that they should receive all of the discovery that they're entitled to without reservation and without exception, so that there is a totally fair prosecution of a case.
Thank you. So this next question is for Ed. Can you talk about the LEAD program and how you envision it being implemented in Tompkins County?
Well, right now the funding for the LEAD program has been suspended in Albany. So the future of it in New York is somewhat uncertain here right now. But the general proposition of this, I am wildly enthusiastic and favor it in being able to give the police discretion about how they're handling matters in the field. Now, you have to remember that the police are being called upon to make instantaneous decisions, sometimes life and death decisions. And the police are entitled to some deference as they do their job in order to protect themselves and to protect the rest of us. But under this program, there would be some discretion about the police. And I would hope that it would be receiving the funding and the enthusiastic support from the legislature in Albany.
Thank you. Matt? Thanks. Law enforcement assisted diversion is what LEAD stands for. And it is a local program. It would be actually a City of Ithaca program. It is not something that is funded by Albany or the state legislature. I am wholeheartedly in favor of it. I sat on the formative task force and went to many meetings talking about how it would be implemented in Tompkins County. It allows for police officers to divert people from the criminal justice system. In other words, they have the option to arrest someone. Someone has committed a crime, but the police officer would, instead of booking them or arresting them, would connect them with a case manager and connect them with services that may have contributed to their criminal behavior. And they never get arrested. They never see the inside of a courtroom, as long as they follow through with that connection. I think that's an incredibly powerful tool that I'm really anxious and excited to implement in Tompkins County. And I think we'll do it in 2020. There's a grant application that we are working and I'm part of right now.
Thank you. The next question is for Matt to answer first. What steps will you take, if reelected, to reduce the number of people incarcerated in state prison?
Well, that's an interesting question. Once people are incarcerated in state prison, it is not in the power of the district attorney's office to affect their sentences. Sometimes they may file a post-sentence motion, and if that has merit, then certainly if there is an issue where they were deprived effective assistance of counsel or something that affects the integrity of their conviction, then absolutely that's the way that I would endorse and I would utilize. But you can't just go back and resentence someone. That there's no procedure legally to do that. We looked very carefully at the number of people in our local jail, and that's something that we're very involved with and have a lot of influence over. And we also only recommend prison when it's absolutely necessary in our cases here in Tompkins County. So that's one way we can certainly affect the population. But once they're in prison, we cannot affect the population.
Thank you. Ed?
Yeah, the district attorney actually has vast authority to affect the prison population. And you do this by being smart on crime, not tough on crime. You do it in the initial charging decisions. You have to think of the district attorney as the gatekeeper to the criminal justice system. The district attorney decides who's going to be prosecuted and what crimes. If the district attorney charges high felonies and those felonies have significant prison sentences on them, you're going to increase the New York prison population. And regrettably, a lot of that increase falls to minorities and people of color. I would make smart prosecutorial decisions and would be very careful about the initial charge that I would bring against someone, because I know if I pursue a particular type of charge, that person's going to end up in prison, and I can affect that directly and immediately.
Thank you. This next question, you're up first, Ed. Will you commit to publicly posting statistical information on charging decisions, convictions, plea bargains, declinations, diversion program placements, and sentences separated by race and gender?
I would be wildly and enthusiastically in favor of doing that, because I'm convinced that is part of the transparency that a proper district attorney's office needs. People need to know the basis of decisions. They need to know the basis of not prosecuting someone. They need to know what type of diversionary programs are being pursued. And I think all of that lead to building the integrity of the criminal justice system and fostering trust and confidence in the system.
Thank you. Matt?
I would love to do that. That would be an incredible tool for transparency in the criminal justice system. We have talked about that specifically in the LEAD program, making sure that the individuals who are diverted are kept track of, and that the community is confident that only white people are not the ones who are being diverted, that people of color are given the same opportunity for diversion as anyone else. So I would love to do that. I would be happy to do that. And it takes resources, which of course I would love to have.
Thank you. Matt, this next question you will answer first. Do you think prosecutors should consider the immigration-related consequences of prosecutorial decisions at all stages of a case and reach dispositions for non-citizens whenever possible? If so, how would you implement that practice in your office?
We do consider immigration consequences to the extent that we know someone's citizenship when they are charged with a crime. It is one factor, but it is not a factor that should control how a case is prosecuted. If it's a violent offense, if it is something that we need to prosecute in order to promote public safety, then we have to put that first and foremost in the calculation of how to handle that case. If it's a nonviolent case and it would have significant immigration consequences, then we need to be more creative and figure out a way that there would be no immigration consequences. But it all comes down to taking the time to assess individually each case and to get to know the individuals, the human beings involved in each case.
Thank you. Ed?
Everyone gets treated fairly and individually, and that takes into consideration their immigration status. We have to be careful locally to thwart the Trump administration policies being enforced by ICE agents with people that have relatively minor crimes that are being snatched up and into the deportation proceedings. I am emphatically opposed to the Trump administration policy of doing that. On the other hand, if there is an illegal immigrant and he has committed a violent crime, that person needs to be prosecuted, and the consequences have been brought on by himself. The third category is that people who are immigrants are entitled to all of the same rights and responsibilities of other people, including being diverted from prosecutions.
Thank you. Ed, this next question you'll answer first. What were the lessons taken for you from the Kaji Ferguson and Rose de Groot matters that should be applied to future cases?
There are a number of lessons to be taken from that. First of all, the Ithaca police officers that were involved in that overreacted. There should have been, to satisfy the public, there should have been an immediate investigation into the overreaction of the police. When you look at the tape, which I have done on many occasions, it is clear that the Ithaca police officers attacked this young man, Kaji Ferguson, and threw him to the ground. The second lesson to be learned from that is that there should be no improper influence upon the district attorney by the police. It's very important for the district attorney to maintain a respectful, proper professional relationship with the police. Under no circumstances would I ever lower charges and dismiss charges and then turn around and go to the grand jury and indict someone on exactly the same charges. That is unethical.
Thank you. Matt?
Thank you. Certainly, there are lessons that I learned from that case, from those two cases. And I think that the major lesson that I learned was that I needed to take more time in the beginning, and then certainly I acknowledge that mistake that I moved too quickly in my analysis of the case. But I vehemently contest any allegation that any police officer influenced my decisions in the case. I made the decisions on my own. I made them after talking to many people from many points of view, advocacy for the defendants, advocacy for the community, and I accept responsibility. But to say that anybody influenced me is baseless, and it's reckless, and it's inflammatory, and I don't agree with it. And going forward, I think communication is the key. And I'm willing to engage in that communication.
Thank you. Matt, this next question you will answer first. How does your office handle arrests for violations of parole or post-release supervision conditions that do not harm or pose a risk of harm to others, such as testing positive for marijuana or failing to report a change of address?
We do not prosecute parole violations or release under supervision, post-release supervision violations. If we come into contact with someone who is on parole, it would be because they committed a new crime that we became aware of, and being on parole complicates how that case is handled. Often, if you commit a new crime while you're on parole, the parole officer will file a warrant which requires you to go to jail without any input from my office, without our recommendation. We have no say in the matter. With that being said, we talk to the parole officer and try to come to a holistic resolution of the case that incorporates what they were doing on parole and their underlying offense and the new charges. But we don't control what parole does with any particular person who is on parole.
Thank you. Ed?
There's a distinction between parole and probation. Parole is a post-release condition of supervision most of which is initially conducted by the New York State Department of Corrections. Probation is a local matter with the Tompkins County Probation Department, and there's two different standards. People have terms and conditions for parole, and they have terms and conditions for probation. Now, I would look very carefully at any allegations of having violated either parole terms or probationary terms, and give everyone the same standard that I do in all prosecutions. And that is that we would look at all of the circumstances of it and decide how we're going to handle it. My goal is not to put people in jail. My goal is to keep people out of jail. People do stupid things, and you have to understand that.
Thank you. Ed, you'll answer this next question first. Alternatives to incarceration are typically used for low-level offenses. Is there a role for ATI in more serious situations, such as violent crimes?
Yes, but it is determined by the nature of the violent crime. If you have an alternative to incarceration with someone who has committed a particularly vicious assault, for example, my interest there would be to protect the victim or the victims. And there may be circumstances where there is a continuing threat to the victims there that would necessitate that there could not be a viable alternative to incarceration. That you'd have to first protect the victims and then think about the defendant. If I was satisfied that there was no risk to the victim, and I would carefully examine that by examining the psychological profile of the defendant, then I would consider something short of incarceration, but it would always be the victim that would be my top priority.
Thank you. Matt?
Well, using alternatives to incarceration for violent offenses is really complicated. It's something that should be considered, but on a case-by-case basis. It may be a form of restorative justice involving the victim. Victims' rights and the status of the victim of a crime, a violent crime, is very important. We need to protect the victims. We need to make them as whole as possible. We need to protect the community, because someone who commits a violent offense may be more inclined to commit violence against other individuals. But certainly there isn't a program such as felony treatment court or wellness and recovery court that would be specific to violent offenders. We would have to take it on a case-by-case basis, but we have to have an open mind about everything and talk it through and do the work to really understand the individuals involved.
Thank you. So this next question you will answer first, Matt. What is your criteria in determining when to charge a child in the youth part of criminal court versus removing the case to family court?
Well, when we're talking about youth part, it relates to felonies committed by individuals who are 16 or 17 years old. So it's very limited. Someone as a 16 or 17-year-old who commits a nonviolent offense does have to be arrested, and the case does start in the youth part of the county court. But universally, those cases are transferred to family court. In order to keep them in county court and to prosecute them in criminal court, there have to be essentially some very aggravating factors, such as use of a weapon to cause injury, a significant injury, or a sex offense. Those are cases that are serious, and we need to balance them out on an individual basis. But the vast majority of 16 and 17-year-olds who are arrested end up in family court, and that's where they should be.
Thank you. Ed?
You have to keep in mind that youth deserve compassion and understanding and a particular sensitivity. Their personalities are not developed. Their mind is not developed. They lack the ability to understand the consequences to themselves. They lack the ability to understand the consequences to their community. They are often possessed of an uncontrollable impulsivity. All of these factors have to be taken into consideration. Layered on top of that, youth may have a traumatic home life. They may have special socioeconomic conditions that warp their sense of well-being and justice. And layered on top of that, you have to understand all of the factors of the particular crime and what justification there are for those things. If you analyze all of those factors and you still have someone who creates a danger to us, then that person has to be prosecuted so that all of us are safe.
Thank you. Ed, you'll answer this next question first. In 2017, a jury found Najee Green guilty for the murder of Ithaca College student Anthony Nazaire. Ed, you have voiced your support for Najee Green's innocence, including signing a letter published on the Ithaca Voice declaring the murder charge wrongful. Can you please explain your position?
Yes, I'm happy to do that. The first thing that you have to remember is that Najee was tried twice. The first time ended up in a hung jury. The second time that he was tried, there were a number of errors that took place during that trial that establish that there is a reasonable question about the integrity of the conviction. Now, most certainly you have to understand that there's a tragic death here, but there's also a tragic life that needs to be addressed here. And because there were errors in the trial, for example, the person who ended up becoming the jury foreman was a former client of Mr. Van Outen. I'm not suggesting that there's anything to that other than the appearance of it creates in the mind of the people that the trial wasn't fair. Everybody is entitled to a fair trial. And without a fair trial, you have the sort of protests that end up in front of the courthouse.
Thank you. Matt?
There were two trials in the Najee Green case. The first trial, Najee Green was convicted of assaulting, stabbing a young man. The second, Ithaca College student who survived, Raheem Williams. The second trial resulted in a conviction of murder, a unanimous verdict of a jury, finding him guilty of murder. There was a post-judgment motion filed, which is extremely common. It's filed in every criminal case, every high-level criminal case, even though it was labeled as highly unusual. That's not true at all. And in fact, the appeal is pending now. The post-judgment motion was denied by the trial judge, who was as familiar with the facts of the case as I was, and the appeal is pending. And if the appeal is heard, I am confident that the judgment will be affirmed based on the evidence. And there was a fair trial. There were two fair trials.
Thank you. Matt, this next question you will answer first. Do you believe that there are any compliance issues in our county regarding the new 2020 automatic discovery laws, which allowed defendants access to evidence at an earlier stage in their cases? If so, what steps would you take to address them?
I don't believe there are any compliance issues. In other words, are we giving what we're supposed to give to the defense attorneys? Absolutely we are. We spent a great amount of time putting together a system that would work in order to collect that information, to compile it, and to send it electronically to the defense attorneys. We have done that in every case routinely within the time limit prescribed by the statute. And that's something that I'm very proud of that we've done. We always had an open file discovery policy, but we are 100% compliant with the new discovery rules that were set forth in CPL, Criminal Procedure Law, Section 245.
Thank you. Ed?
It's important for people to understand that the discovery rises to the level of fairness and constitutional rights. Everybody is entitled to a fair trial. You can't have a fair trial until everything has been properly and fully disclosed to the defense counsel within enough time period in order to make certain that they understand it and they can use the material. The protocols that are established by the new legislation establish very strict time periods for doing that stuff. That's all proper. And under my administration, everything would be disclosed well before the time that it's required to be disclosed in a matter of fairness, in a matter of justice.
Thank you. This is our last question, and you may feel free to answer it as a yes and not elaborate if that's your response. The last question, Ed, you can go first. Will you support the winner of the Democratic primary, or will you seek a different party line to run on?
No, I will unhesitatingly support the winner of the primary, and I personally will not seek another line because I will be satisfied that the people have had a chance to make their decision, which was something that was deprived to them 4 years ago. But once the people have spoken, that's all that I'm interested in. I'm totally satisfied, and I'm delighted to support the Democrat nominee.
Thank you. Matt?
Yes, I will. I would have before, and I will now. I'm a lifelong Democrat, and I am a loyal Democrat, so yes.
Thank you both very much. We are now going to move into closing statements, and we will be reversing the order. So Matt, you will go first. You will have 1 minute, and then Ed will go.
Thanks. Public safety and justice. Justice is not one size fit all. As a prosecutor, if you think that it is, you're dead wrong. No matter what the case is, how big or small it is, human lives are affected, and we need to take that into account. So I graduated from West Point 30 years ago, but so many of the values that I learned there have stuck with me over my lifetime. For example, the honor code, a cadet shall not lie, cheat, or steal, nor tolerate those who do. And also the importance of choosing the harder right over the easier wrong. It might be easier to cut corners or tell half-truths in order to win in the short term, but ultimately the results of those half-truths and those lies are a sham, and they're not justice for the community. If a prosecutor is willing to lie about something in their personal life, they're willing to lie about it in court in their professional life. And that's not appropriate for a prosecutor. Integrity is the first and foremost quality that a prosecutor needs. So I ask the voters to exercise due diligence, talk to people, and above all, vote on June 23rd.
Thank you. Ed?
The word crisis in the Chinese language, when written in characters, means that there is both a danger and an opportunity. There is a danger here because of the distrust in the system that we have here right now. Mr. Van Outen has said that he would love to have transparency in his office regarding all of the statistics and the charges and the dismissals, but he's had 4 years and he hasn't done anything. Mr. Van Outen says that he is in favor of the Lgbtqia and the training, but he's had 4 years and he hasn't done anything about that. People are protesting in front of the courthouse. There's an injustice. That's the crisis aspect of this. The opportunity that we have is that we can pull together. We can change this system so that everyone has a fair sense about this. And injustice to one person is an injustice to everyone. I urge you to join with me. Help me change this system. Make me the district attorney, and we will have an opportunity for everyone to feel involved and safe and just in this system. Thank you so much.
Thank you very much. So I want to give a big thank you to both of our candidates. Thank you so much, Ed. Thank you so much, Matt. We went through a lot of questions, and it was clear that you were both really, thoughtful, and really appreciate the opportunity for the Democratic Committee to be able to, put this out there. So I will now turn things over to Jim, who just needs to unmute himself, and he will wrap us up for the evening. Thank you, Jim.
Well, thank you, Liz, for really a very good job of moderating, and thanks to both the candidates for their full participation, and to Renee for the very taxing job of keeping track of the time. So I'll just wrap this up by saying that we do have 2 more forms for the assembly race on May 27th at 7 o'clock. We'll be sending out notifications and invitations to join the meeting, and it will be also live streamed as this one has been, and recorded. And then another one on June 9th with the same setup. Thanks again to all, and may you all stay safe and healthy and be well. And thanks again to our crew that's really helped us put this on. Great team effort. Good night to all. Thanks.
Thank you.
Thank
Jim,
you.
thanks for your